This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
What if I told you that in Florida, a business mogul could owe like $10 million to unsecured creditors, file for bankruptcy, and still legally keep a $10 million beachfront mansion completely untouched by the people he owes money to?
I think it sounds like a joke, right?
Right. Okay, it sounds completely made up.
Yeah.
But today, we are decoding a stack of legal sources detailing the very specific and honestly incredibly powerful bankruptcy protections available in Florida. We're going to figure out how state laws and federal laws collide to create, well, some of the strongest debtor shields in the country.
Yeah, they really are.
And we'll explore the immediate legal mechanisms that stop creditors in their tracks, contrast the two main paths for erasing debt, and break down the actual physical limits of Florida's asset protections. And then look at which debts are bulletproof and survive this process no matter what.
Yeah, because that mentioned scenario, it sounds like a massive loophole, but it's actually a deeply entrenched feature of the system.
A feature, not a bug.
Exactly. To really understand this deep dive, you have to look at bankruptcy not as a punishment, It's a heavily regulated structural trade. The Federal Bankruptcy Code was designed to provide an honest debtor with a fresh start while utilizing state-specific laws to dictate what assets you are actually allowed to keep.
It was an exchange.
Right. It's a calculated exchange. You subject your entire financial life to federal court scrutiny, and in return, the court uses state laws to ensure your basic livelihood, like your shelter, your income to feed your family, remains intact.
Okay, let's unpack this because, we're talking about a trade, but before anyone even gets to the point of negotiating that trade, there's usually, a crisis.
Right. People are usually panicking.
Exactly. If you're the one drowning in debt, you aren't thinking about long-term strategy. You're thinking about the wage garnishment notice you just got, or the foreclosure threat, or the phone ringing 20 times a day from debt collectors.
Yeah, it's incredibly stressful.
So let's look at the mechanism that actually stops that bleeding first.
Right. So that mechanism is called the automatic stay. It's under 11 U.S.C. Section 362. And it isn't just a suggestion to creditors. It is an immediate federal injunction.
Like the exact second you file.
The exact second. The moment a bankruptcy petition is filed and time-stamped by the court clerk, this order goes into effect. It effectively draws like an invisible federal perimeter around the debtor and their property.
Okay, I like that. A perimeter is kind of like a legal freeze ray.
Yeah, a freeze ray is a great way to think about it. Any creditor, debt collector, or landlord who crosses that perimeter to, demand payment or file a lawsuit or garnish wages, they are in direct violation of a federal court order.
I want to visualize that freeze ray, though, because if it's a federal injunction, it's not just hitting pause on a phone call. If a creditor ignores it and calls you anyway, they aren't just bothering you.
No, they are in contempt of a federal judge.
Wow.
And that is the crucial distinction. The court can and will sanction creditors who willfully violate the stay. They can be forced to pay your attorney's fees or even punitive damages.
That's huge.
It is. It forces a complete hard stop on commercial collection activities so the court can actually organize the estate.
But let me test the strength of that freeze ray. In law, there's rarely a shield that blocks like every single weapon. If the goal is to stop commercial creditors, what happens to non-commercial obligations?
Right. So the perimeter has very deliberate, highly specific exceptions built into the federal code. And these are mostly driven by public policy.
Like what?
Well, the most prominent is the criminal justice system. A bankruptcy filing does not halt a criminal prosecution. If you owe, say, criminal restitution or fines, the stay won't stop the state from pursuing you.
Okay, that makes sense. You can't just bankrupt your way out of a crime.
Exactly. And another major exception is domestic support. So if you owe child support or alimony, the collection of those obligations will continue, provided, the money is being collected from property that isn't part of the bankruptcy estate, like your current wages.
Okay, wait. That brings up a really interesting tension. Because if we are talking about current wages, Florida has a proactive shield that operates entirely outside of bankruptcy, right?
Oh, yes.
Yeah, because the sources highlight this state law, the head of family wage exemption, that protects your paycheck before you even file a single court document.
It's arguably one of the most robust wage protections in the entire country. Under Florida statute 222.11, the law defines a head of family as someone who provides more than 50% of the financial support for a child or another dependent.
And wait, notice that it does not say you have to be married.
Right. It doesn't say you have to be married or even that the dependent has to live with you. If you meet that 50% threshold, the state grants you massive protection against wage garnishment.
Let's dig into the math of that protection, because it's tiered based on income, isn't it?
It is, yeah.
So if your disposable earnings, and by that the law means your take-home pay after required withholdings like taxes and Social Security, if that is $750 a week or less, every single penny is safe. Creditors literally cannot touch it.
Not a cent. And if your take-home pay exceeds that $750 weekly threshold, the protection doesn't just disappear.
Or it doesn't.
No, those wages are still completely protected from garnishment, unless you have signed a very specific written waiver agreeing to let a creditor take them.
I want to pause on that waiver. Because anyone who has ever signed a loan or, I don't know, a credit card agreement knows you sign 50 pages of dense legalese. How easy is it for a creditor to sneak a waiver into, like, page 37 of a contract?
Well, the law specifically anticipates that exact predatory tactic, which is why it regulates the physical appearance of the waiver. It cannot be buried in the fine print.
Oh, nice. So what are the rules?
State law dictates that the waiver must be a separate document attached to the contract, written in the same language as the contract, and printed in at least 14-point type.
14-point type. That's pretty big.
It has to be glaringly obvious. If a creditor fails to meet those exact formatting requirements, the waiver is completely invalid and your wages remain shielded.
Okay, so the paycheck is protected when your employer cuts it. But let's look at the reality of modern banking, right?
Right.
Your employer direct deposits that money into your checking account.
Right.
And let's say you also sell a bicycle on Craigslist for $300 and deposit that cash into the same account. Then a creditor freezes the account. How does the bank, or the judge for that matter, know which dollars are the protected wages and which dollars are fair game?
Yeah, that is where things get complicated. And it introduces the concept of the tracing rule. Florida law says your exempt wages remain protected for 6 months, even after they sit in a bank account.
6 months, okay.
However, the burden of proof flips to you. You have to trace those funds. When you commingle protected wages with unprotected cash, like the bicycle sale you mentioned, you usually have to rely on accounting principles.
Like what kind of principles?
Things like first in, first out, or the lowest intermediate balance rule, to prove to a judge that the specific dollars the creditor wants are actually the ones that came from your employer.
Man, that sounds like a nightmare to prove in court. So the practical takeaway there is, if you are relying on that head of family exemption, do not mix your money.
Absolutely.
Keep a separate account just for your payroll deposits to make the tracing undeniable.
Yeah, it's the smartest move you can make.
Now, assuming you've utilized these immediate shields, the automatic stay, the wage protections, you eventually have to choose a structural path to deal with the underlying debt.
Right, the long-term fix.
Exactly. And the sources focus primarily on 2 routes for individuals, Chapter 7 and Chapter 13.
Right, and the choice between those 2 chapters really defines what you are willing to trade.
Okay, let's start with Chapter 7.
So Chapter 7 is a liquidation process. It is fast, typically resolving in 3 to 6 months. In a Chapter 7, you are asking the court to completely discharge or wipe out your unsecured debts. So credit cards, medical bills, personal loans.
But there's a catch.
Catch. The trade-off is that a court-appointed trustee has the authority to gather any property you own that is not protected by state exemptions, sell it, and distribute the proceeds to your creditors.
But there's also a gatekeeper. You don't just get to opt into a quick wipeout because you feel like it.
No, you definitely don't.
The federal government uses the means test to block high earners from using Chapter 7. How does that work?
The means test is a strict mathematical formula designed to prevent abuse. First, it looks at your household's average income over the 6 months prior to filing. If you fall below the median income for a Florida family of your size, you generally pass.
So you're allowed to file Chapter 7.
Exactly.
But what if you make above the median? Let's say you had a great salary, but your debt is just astronomical.
Then the test forces you into a second calculation, measuring your current monthly income against allowed monthly expenses to determine your disposable income.
Okay, so just my bills minus my income.
Well, here's where it catches people. You don't get to use your actual expenses.
Wait, really?
Really. You can't claim a $1,000 a month luxury car lease as a necessary expense. The court uses standardized, localized IRS expense figures.
Oh, wow. So they tell you what you should be spending.
Pretty much. If, after applying those standardized expenses, the formula shows you have enough disposable income to pay a meaningful portion of your debts, you fail the means test. You are barred from Chapter 7.
Which forces you into the other path, Chapter 13. And Chapter 13 operates on a completely different logic. It's not a liquidation, right? It's a reorganization.
Right. In Chapter 13, there is no liquidation of your assets. You keep your property. Instead, you propose a structured repayment plan to the court, lasting 3 to 5 years.
3 to 5 years, that's a long time.
It is. You consolidate your debts and make one monthly payment to the trustee, who then distributes it to your creditors. Your payment amount is basically based on your disposable income and the value of any non-exempt property you are keeping.
So Chapter 13 is for the person who fails the means test. But it also seems like the strategic choice for someone trying to save a specific asset.
Yes, very often it is.
Say you are, I don't know, $10,000 behind on your mortgage, and the bank is threatening foreclosure. A Chapter 7 wipeout won't save the house because the mortgage is tied to the property itself, right?
Precisely. Chapter 13 allows you to cure those arrears. You can spread that $10,000 deficit over the 3 to 5 year life of your bankruptcy plan while continuing to make your regular ongoing mortgage payments.
So you just catch up over time.
Yeah, as long as you stick to the plan, the automatic stay keeps the bank from foreclosing. You are essentially using the federal court to force the bank to accept a catch-up plan.
But you are locked into court supervision for up to 5 years, and you don't get your discharge until the final payment clears.
Yeah, it's a marathon.
That is a massive psychological and financial commitment compared to a 3-month Chapter 7. Is there any reward for completing that marathon other than keeping your stuff?
There is, actually. There's an incentive known as the broader discharge. Because you made a good faith effort to repay creditors over several years, the federal code rewards you by discharging a few specific debts at the end of a Chapter 13 that would actually survive a Chapter 7.
Oh, interesting. Like what?
For example, if you owe a debt because you willfully damaged someone else's property, or you owe certain debts arising from a property settlement and a divorce, a Chapter 13 discharge will erase them. A Chapter 7 will not.
So what does this all mean? Basically, Chapter 7 is a quick wipeout for lower income earners, while Chapter 13 is a longer reorganization to save major assets.
That's the perfect summary.
But this brings us to the core anxiety everyone faces when they consider bankruptcy, particularly Chapter 7, the fear of liquidation. The idea of a trustee pulling up to your driveway and taking your couch, your car, and your television.
Right, the Repo Man image.
Exactly. But the sources indicate that in Florida, this is largely a myth because of exemptions.
It really is. The vast majority of individual Chapter 7 filings in Florida are classified as no-asset cases.
Meaning there's nothing to take.
Well, it means that while the trustee has the theoretical power to sell your stuff, every single item the debtor owns falls under a state exemption category. When property is exempt, the trustee absolutely cannot touch it. And Florida has engineered some of the most impenetrable exemption fortresses in the country.
Let's talk about the main fortress, the Florida homestead exemption. It is famous in legal circles because, unlike almost every other state, Florida places no dollar limit on the equity you can protect in your primary residence.
It's incredible. Enshrined in the state constitution, it shields the entire value of your home from forced sale by creditors. Whether your home is worth $50,000 or $50 million, the protection holds.
But there are physical boundaries. It's not unlimited land. The state constitution caps the physical footprint to ensure you aren't, like, protecting a massive commercial farm under the guise of a homestead.
Right. The geographic limits are strict. If your property is located outside a municipality, meaning a rural area, you can protect up to 160 contiguous acres.
Okay, 160 acres.
But if your property is located inside the limits of a municipality, the protection shrinks dramatically to just 1/2 of an acre.
That urban limit raises a huge practical issue. What if you own a 2-acre lot inside city limits? The house itself only sits on a fraction of that, but the land obviously exceeds the 1/2-acre rule. Can the trustee actually slice up your property?
Yes, they can, through a legal mechanism called partition. If the property can be physically divided and sold, the trustee will do exactly that, leaving you with the protected 1/2 acre and selling the rest to pay creditors.
What if it can't be divided?
If local zoning laws make it impossible to divide the property, the trustee might force the sale of the entire parcel, give you the value of the exempt 1/2 acre, and keep the remaining funds for the bankruptcy estate. The geographical boundaries are rigidly enforced.
Wow, now we have to address the bankruptcy tourism loophole. Because if I owe millions in New York and Florida has an unlimited homestead exemption, what stops me from selling my assets, buying a Florida mansion for cash on a Tuesday, and filing for bankruptcy on a Wednesday?
Well, Congress saw that exact strategy being exploited and amended the federal code to stop it. They implemented the 12,215 day.
12,215 days.
Right. To claim Florida's unlimited homestead exemption, you must have owned the property for at least 12,215 days, which is roughly 3 years and 4 months prior to filing your bankruptcy petition.
And if you haven't hit that mark, let's say you've only owned the Florida house for 2 years, does the fortress just collapse?
It doesn't collapse entirely, but federal law overrides the state constitution. If you haven't owned the home for the required 12,215 days, federal law imposes a hard cap on your homestead exemption. Currently, that cap is around $189,000, though it adjusts periodically for inflation.
Okay, so still a decent chunk, but not unlimited.
Right. Any equity you have above that federal cap becomes exposed to the trustee, regardless of what the Florida Constitution says. Furthermore, just to use Florida's exemptions at all, you must have been domiciled in the state for a full 730 days, 2 full years before filing.
Oh, so you have to establish residency for 2 years first.
Otherwise, you have to use the laws of the state you moved from.
Okay, so the house is shielded if you navigate the timelines. What about the rest of your life? Like your car?
Florida state law provides a $5,000 exemption for equity in one motor vehicle. They also offer a wildcard exemption of $1,000 for personal property, which you can apply to furniture, electronics, or cash in the bank.
But the sources reveal a fascinating structural shift in those numbers depending on whether you own a home.
Yeah, this is a great feature.
If you do not claim the homestead exemption, like maybe you rent or you simply choose not to use it, that wild card jumps from $1,000 to $4,000.
It acts as an equalizer. The state recognizes that renters shouldn't be completely penalized for not owning real estate, so they offer a slightly larger shield for personal property.
Here's where it gets really interesting, though. There's another, even more specific adjustment in the law that kind of blew my mind. It's a legal hack regarding medical debt. Florida law actually changes the size of your exemption shield based on who you owe money to.
It is a highly unusual provision, yeah. If the debt you are trying to discharge stems specifically from a licensed hospital or healthcare facility, for instance, a massive, unexpected emergency room bill, Florida, dramatically increases your protections against that specific creditor.
To what?
Your vehicle exemption doubles from $5,000 to $10,000. And your wildcard exemption, assuming you aren't claiming a homestead, jumps from $4,000 up to $10,000.
That is wild. It's as if the state legislature is actively acknowledging that medical debt is largely involuntary. You don't choose to get into a car accident and incur $100,000 in trauma bills, so the state builds a thicker wall to protect your car and your cash from the hospital's collection attorneys.
Exactly. It is a clear policy choice to prioritize a debtor's basic transportation and liquidity over a medical institution's right to collect.
But while Florida can build these localized walls, federal law always has the final say on which debts can actually be destroyed. Bankruptcy is powerful, but there's a strict list of non-dischargeable debts that will survive the process intact, piercing right through those state exemptions.
The federal code lists these out meticulously under 11 U.S.C. Section 523. We've established that domestic support obligations survive. You also cannot discharge certain recent tax debts. The government ensures it gets paid first.
Student loans are the one everybody asks about, though. There's a persistent myth that you simply cannot bankrupt a student loan.
Well, it isn't entirely impossible, but the threshold is exceptionally high. To discharge a student loan, you have to initiate a separate lawsuit within your bankruptcy and prove to the judge that repaying the loan would impose an undue hardship on you and your dependent.
And what does undue hardship actually mean in a courtroom?
Yeah.
Because for most people, paying $1,000 a month feels like a hardship.
Yeah, but feeling burdened isn't enough for the court. Courts typically use a very strict standard, often requiring you to prove 3 things. First, that you cannot maintain even a minimal standard of living if forced to repay. Second, that this grim financial situation is likely to persist for a significant portion of the repayment period.
Basically proving you'll never make enough.
Right. And third, that you have made good faith efforts to repay the loan in the past. If you have a degree and the physical capacity to work, it is incredibly difficult to win that argument.
The federal code also explicitly targets bad behavior, right? The fresh start is reserved for the honest but unfortunate debtor. If you obtained money through fraud or if you embezzled funds, those debts survive.
Exactly. The court will not allow bankruptcy to be used as a shield for malicious acts. If a creditor can prove you intentionally caused malicious injury to a person or their property, or if you have court-ordered restitution from a criminal conviction, the bankruptcy discharge will definitely not erase those obligations.
There's also a mechanical limitation on how often you can use this system. You can't just run up your credit cards and file Chapter 7 every 3 years.
No, the system imposes a strict time bar. If you received a discharge in a previous Chapter 7 case, you are legally barred from receiving another Chapter 7 discharge for 8 years.
And the mechanics of that timeline are brutal. The clock does not start on the day you received your last discharge, when you finally felt free. It starts ticking on the exact date you filed the previous petition.
Yes, the petition date.
If you file a new case 7 years and 360 days after your last filing date, your case will be dismissed, and you lose the filing fee.
It requires absolute precision, which brings us to the actual execution. If someone listening to this understands the shields, the exemptions, and the timelines, what does the physical process of filing actually entail?
Step 1 actually happens outside the courtroom. The federal government requires you to undergo credit counseling from an approved agency within the 180 days before you even file a petition.
Right.
Why force counseling on someone who is already at the point of bankruptcy?
It is an initial filtering mechanism. The counseling is designed to objectively evaluate whether you actually need bankruptcy or if, an informal repayment plan outside of court could resolve your issues. You must file the certificate of completion with your petition, otherwise the court will throw the case out.
Okay, so once you have that certificate, you file the petition, which triggers the immediate automatic stay we talked about. But that petition is just the cover page. Within 14 days, you have to submit your schedules. And calling them schedules almost downplays what they are. It's a complete financial autopsy.
Oh, absolutely. You are required, under penalty of perjury, to list every single asset you own, down to your clothing and your pets.
Even your pets.
Yes, even your pets. You must list every creditor you owe money to, even the ones you want to keep paying. You must detail your current income, your exact monthly expenses, and your past tax returns. Furthermore, the court requires a statement of financial affairs which looks backward in time.
That look-back period is critical. You can't just transfer your boat to your brother the week before you file and say, "What boat?"
No, you really can't. The trustee has profound investigative powers. They will scrutinize your financial history for the past 2 to 4 years, looking for preferential payments to specific creditors or fraudulent transfers to family members.
So what happens if they find one?
If they find you moved an asset out of your name for less than it was worth just to hide it from creditors, the trustee can legally undo that transaction, pull the asset back into the bankruptcy estate, and sell it.
Wow. That investigation leads directly to step 3, which is the 341 meeting, named after the section of the code, or the meeting of creditors. I think pop culture has completely distorted what this is. People imagine a wood-paneled courtroom, a judge glaring down from the bench, and a jury box full of angry credit card executives demanding their money.
Yeah, that's what everyone thinks, but the reality is incredibly mundane. Judges are actually strictly prohibited from attending this meeting. It usually takes place in a nondescript conference room in a federal building, or increasingly, over a simple video conference call. It is administered entirely by the trustee.
Do the creditors actually show up to grill you?
In a standard consumer bankruptcy, almost never. Large financial institutions do not spend money to send a lawyer to ask you about a $5,000 credit card balance when they know you have no non-exempt assets.
Who does show up?
The only time creditors typically appear is if it is, say, an ex-business partner, a former spouse, or someone who specifically suspects you are hiding assets.
So what actually happens during the meeting if no one shows up?
You provide your identification, you raise your hand, and you swear an oath. The trustee then asks you a series of standardized questions to verify the information in your exhaustive schedules. Things like, did you list all your property? Did you list all your debts? Have you read the bankruptcy information sheet?
Sounds pretty fast.
Assuming you have been honest and thorough, the meeting often lasts less than 10 minutes.
That leads to the finish line. After completing a secondary, mandatory financial management course, the wait begins. In a Chapter 7, if no one objects, about 3 to 6 months after you filed that initial mountain of paperwork, you receive a single document in the mail.
The discharge order.
The discharge order. The debts that can be erased are legally gone, and the court closes the case.
It is the culmination of the entire structural trade. You surrendered your financial privacy, you subjected your assets to federal scrutiny, and in return, you receive the fresh start the law promised.
It really is a fascinating collision of federal power and state sovereignty. The bankruptcy process demands brutal honesty and exact precision, but the tools built into Florida law, from the proactive head of family wage shield to the impenetrable homestead exemption, they provide incredible leverage for someone trying to escape the quicksand.
But leverage is only useful when applied correctly. The core takeaway from these sources is that timing and verification are everything. You cannot guess your disposable income, you cannot estimate the date you bought your house, and you cannot assume a debt is dischargeable without checking the code.
Exactly. Know the rules before you play. Now, I want to leave you with a different perspective to mull over. For this entire deep dive, we have explored these laws as shields for the debtor. But laws cut both ways. If you are a small business owner in Florida, a contractor, or someone extending credit, how does understanding the sheer strength of these debtor protections change your calculus tomorrow?
Right, because it really flips the dynamic.
Because the exact same homestead exemption that acts as a life raft for a family in debt means that, as a creditor, if you don't secure your loans properly, you might watch a debtor walk away completely untouched while your invoice disappears into the void. It's all about which side of the shield you stand on. We'll catch you on the next deep dive.
This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.